insurance broker that is seller focused through an auction process and helps people benefit from unwanted, unneeded life insurance policies through the life settlement process. This meeting is sponsored by John Kramer of Kramer Insurance Partners, one of our advanced independent life insurance professional who is very experienced in this arena. Other upcoming meetings, October 1st, we've got the nationally noted philanthropic and charitable planner, Linda Sands. She's going to be presenting on the philanthropic and charitable conversations with our clients. She's going to continue that, and always a challenge, but she will do a deep dive into really the discovery processes that is the linchpin to her expertise. We've got the NAEPC's annual Advanced Estate Planning Strategies Conference, October 20th to 24th at Disneyland. November 5th, we've got Stuart Moss, past president of ACG, here with a panel that's going to continue our business exit planning series. And then November 3rd to 7th, the Hawaii Tax Institute is going to be going on, and I can't commend that enough. More information to come. Certainly, we have our trifectas, just to give you the heads up. Pete, are you around? Pete Tentler, board member, networker extraordinaire.
Thank you, Bill. Trifecta has been a really good success. For those that are new here, this is an opportunity that I'm going to pair you up with two other people. Hopefully, I'm going to pair you up with other people that are going to complement your industry and not compete, and get together for coffee, lunch, happy hour, if you will, and just get to know each other on a more personal basis. I'm going to pass around the fishbowl. I'm going to start with that table all the way down there, and just pass around. Drop your card if you want to participate in the trifecta. Any questions, give me a call. Thank you.
For those zooming in, certainly email me before noon today, and we'll add you to the fishbowl. Want to introduce you to our nonprofit spotlight folks. Executive Director Rosalind Knox and Angela Pernella of the San Diego Brain Injury Foundation, and welcome, and come on up and say your thing.
You guys will all be able to hear me. I really want to use the room to make sure that everybody can hear. You might take it off. My name is Angela Pernella. I'm a Jersey girl. And I'm going to go back to 2002. It was May 24th, 2002. I was working in Manhattan, New York City. It was my first job out of college. I took the bus home from the Port Authority station on 42nd and 8th, and I took that home to a beautiful place called Ringwood, New Jersey. It was like I said, it was my first job outside of college, and I was living at home with my parents. Got out of the bus, into my car. It's probably about 2 minutes from home. It was a beautiful sunny day. It was a Friday before Memorial Day weekend. I really couldn't wait for the weekend to start. I think I had plans that day to maybe play in a beach volleyball tournament down at the Jersey Shore. I played Division I college volleyball. And so getting on the beach again after college was really important to me. So it was about 2 minutes from home. Life was going good. And then pow, boom. A reckless driver going over 55 miles per hour hit me head on. Going over 35 miles, going 55 miles per hour in a 35 mile per hour zone. He hit me head on. Changed my life. In an instant, paramedics came. They used the jaws of life. They cut me out of the car. I don't remember anything. Actually, there are some memories that I have. I'm not going to get into all those details. That's a story for another time. They saved my life. They medevac me to a level 1 trauma center, Hackensack University Medical Center. If any of you know where that is in New Jersey, it's an amazing trauma center. And that's where they saved my life. Some of the injuries, I'll just give you the Cliff Notes version of what happened to me. I had over 1,000 stitches to my face and my body. I've got some on my bicep here, little scars. I had 4 broken ribs. In fact, I was slumped over the console. I couldn't get to my cell phone because of these ribs being broken. The last thing I looked at before I lose consciousness was the blood on my hands. I remember that after going to EMDR therapy and going back to those memories to remove some of that trauma from my body and my brain, moving it from short-term memory to long-term memory. So when everybody has questions about EMDR therapy, come see me after the talk. Other things that happen, I had double vision. I was 23 years old, guys. I was walking with a walker. I lost my 20s. Gosh, there were so many injuries. Mesenteric contusion, which is your intestines, renal contusion. My lung was punctured. I lacerated my liver. My skull was stitched and stapled. And I had a severe traumatic brain injury. You wouldn't know that by looking at me now. Sometimes you can't see a TBI. Sometimes you can't see an acquired brain injury. That recovery period lasted, well, I was in surgical ICU, and then I went home and I was with my parents. The physical therapist came to the house because I couldn't move. My parents were giving me medicine every 4 to 6 hours. This is after I was out of the hospital. The physical therapist would come. Then eventually I was getting better. I had double vision. It was summertime. I was wearing a hat and a sweatshirt because I couldn't let any of the scars be exposed to the sun. And then, gosh, it was some time going to speech therapy, playing that game of memory. Who remembers the game of memory when you were like 5 and 6 and 7 years old, playing that with mom and dad? I was doing that at 23, getting my speech back. Eventually, through the healing, I did some neurofeedback therapy, which is amazing. I think everybody should get a brain mapping and do neurofeedback, whether you've had a TBI or not. That's a story for another time as well. Heart rate variability training, I do that most mornings. That's the milliseconds between each heartbeat to make sure that we're in a more parasympathetic state. Our nervous system can be in survival mode, and my nervous system was in continuous survival mode. In fact, some of you might be in survival mode right now. We're just kind of going through the motions. So it's part of my life mission. After that trauma, it gave me perspective on life, how fragile it is. It gave me purpose. It gave me more purpose. And that big purpose was to be a motivational speaker. And I made a decision after that accident that I was going to be a motivational speaker to inspire, educate, challenge, and motivate people to never stop believing in themselves and to teach them how to think. So when the curveball comes, whether it's a loss of a family member, something happens with the kids, you lose your job, you get hit by a car, you're driving recklessly. I don't know if he was texting and driving, but he wasn't paying attention. And so I want us all to pay attention behind the wheel, but that's another story for another day. Part of my life mission is to be an advocate and a bold, loud voice for the San Diego Brain Injury Foundation and really across the country. I've reached out to the Brain Injury Association of America. In fact, did you know that 2.5 million people every year suffer a traumatic brain injury, suffer head trauma and a brain injury in the United States? And we need to know about that because it can happen every single day. Some of you I spoke with this morning know somebody that's had a concussion or a stroke. And so it's important that you guys know the resources here for those survivors and for their family members. So I'm going to invite Rosalind Knox up to talk a little bit more about the programs that we have and what we're doing to bring awareness, and then I'll wrap it up after her.
Thank you so much. Thank you, Angela. And thank you all for having us today. The San Diego Brain Injury Foundation has been in San Diego serving families and survivors of traumatic brain injury since 1983. We are what are considered the resource hub for brain injury survivors. And you hear Angela's story. And again, yes, you look at Angela, you do not see a traumatic brain injury. You may think, oh, well, what? I have a survivor that said a phrase one time that has stuck with me forever. And she said, it is like waking up and you are at war with your brain every single day. And I thought, imagine that. You're trying to tell your brain to go in and brush your teeth, and it's scrambled like a puzzle piece that's thrown into the air. And you have to figure out, and you're battling thoughts every day, trying to put things together. And most people don't recognize that. We have people that have brain injuries and they get out of the hospital. They are in rehab for a certain amount of time, and then they have nowhere, do not know what to do. The San Diego Brain Injury Foundation connects people to resources, to various, you've heard Angela talk about neurofeedback. There are various other types of things that people need. They need physiatrists and neuro-ophthalmologists and all of those things, and they have no idea which way to turn. We offer our services for free because we have a community such as yourselves that support and are part of the brain injury community, that want to be there to help people reset their lives, because our mission is to improve the quality of life. We have programs that include peer support groups, that we connect people to community reintegration services and programs. We connect them to various social services and different things that help guide them. We put together an action plan for them, because you'll see on your table, there's a brain injury guide. And most people do not even recognize the next step to take. And so we help put together that action plan, help reintegrate them if they are in a level that they will be ready to prepare for work again. We do vocational reintegration, community reintegration, but most importantly, we help survivors and their families hold on to that hope, understand that it may not always be this way. As you heard Angela say, she's 23 years old and walking on a walker. She's not walking on a walker today. But we have so many survivors that do not see that part in their lives. And that's what we're here for. And that's what we bring communities together for, is to provide that. And so today we're here to say to you that support the brain injury community. Of course, we'd love for you to support the San Diego Brain Injury Foundation, because we support families, we support survivors. But whatever you do, when you know someone or you know of a family that are going through something, that a loved one has had a brain injury, support them with kindness and patience, and let go of expectations, because they are now having to reset their lives and they need all of us there for them. So thank you so much for having us today. If you need any more information, please feel free to ask Angela or myself.
I just want to close the talk out. When I'm not selling real estate, I'm building hope and I'm helping people with healing. So of course, I'm going to ask you, who do you guys know that I should know and that Rosalind and I and the foundation should know that we can help? So our contact information is here. If you'd like, we can talk afterwards a little bit more. Maybe you guys know somebody, a family member. And so it's just a matter of staying connected. That's why we all showed up this morning, is to stay connected and help one another. So thank you for listening. Thank you to Bill and for all of you. Thank you very much.
Angela, Rosalind, thank you so very much. We certainly try to highlight our nonprofits, and certainly if you all have financial need solutions or anything else, be sure to contact them. Certainly, I'm thrilled and honored to introduce you to our speaker today. I heard her speak at last year's Heckerling, though I think she's been prolific and not exactly on my radar, but Kim Kamin is a partner at Gresham Partners, which is an independent wealth management firm serving as a multifamily office for about 120 families nationally. Previously, Kim was a partner at a large law firm known for its estate planning practice. At Gresham, Kim serves as Chief Wealth Strategist, leading the development and implementation of estate wealth transfer planning, trust and estate administration, philanthropy, and rising gen education and engagement activities. Kim is based in Chicago and teaches at Northwestern University Law School and University of Chicago Business School. She's a regent for the American College of Trust and Estate Council, ACTEC, is on the editorial advisory board of Trust and Estates magazine for their high net worth families and family office committee, and is an estate planning domain chair for the Ultra High Net Worth Institute. Last year, Kim was inducted into the National Association of Estate Planners and Councils, NAPEC, Estate Planning Hall of Fame. She has received numerous other professional awards, speaks nationally on a regular basis, works across the country, has written extensively on wealth transfer planning topics, and is co-authors for the Lineberg Library book on estate planning for modern families with Wendy Goff, who we had speak 3 years ago on dealing with addiction and mental health families. So without any further ado, Kim Kamin.
All right. I just got a little more time so that we can have a robust Q&A afterwards. Although if you need to leave by 9, please feel free to go. So thank you so much, Bill, for that very warm introduction. And thank you also for inviting me to come to this area of the country where I have never been precisely. I've been in San Diego. I've spent a lot of time in Los Angeles. I used to live in Hermosa Beach, Manhattan Beach area after I graduated from college in Northern California. My son is currently in college at Claremont McKenna College, so also in California, and I love any excuse to be here. In fact, we have a lot of clients lately who have been hiring us from California, and as I was saying to somebody, they say, well, we have all of these resources. Why shouldn't we live in the most perfect place to live in the world? Why should we be moving to these other states and towns where we are not going to have the lifestyle that we would prefer to have here? So that's been very interesting. So as Bill mentioned, he did see this panel presentation that we did at Heckerling. And just out of curiosity, how many of you participated in Heckerling either in person or virtually and saw the program that we did on directed trust, family offices, and private trust companies? Oh, good. Oh, I thought I had turned all that off, but that's telling me that it's time to wake up in Chicago. All right. So that's great. So the materials that I'm going to be covering today actually do fit pretty closely with the PowerPoint that we had prepared for that program. But we had 90 minutes then and have a shorter time now. So I'll try to be brief, and also recognizing that it looks like a lot of you are not day-to-day estate planners, that some of your perspectives on some of this content might be a little bit different. So I'll try to accommodate all of you and not go too far into the weeds. Give you just enough. And for those of you who want more, the outline that's been handed out does go into some more detail. All right. Slide, please. So what we're talking about is really tackling the intersection between directed trust, family offices, and private trust company. As you can see, there's a lot of overlap because clients in their structures may have 1, 2, or all 3 of these structures in place. So we can use any one of these structures either alone or in combination with the other 2. Slide. And what we're going to talk about first is directed trusts. I understand that you had someone speaking about that here in May. So I'm going to try to not rehash what you talked about in May, but go a little bit deeper. Then we'll talk about family offices in 2 parts, both an overview of family offices and a bit about family office structures, and then a bit about private trust companies. And my goal is to leave plenty of time for Q&A so this can be interactive. But as I'm going along, if you have questions or you want me to clarify something or interject on something that you think will benefit the room, by all means. This is a small enough group, at least for those of you here in the room whose hands I can see. Please don't hesitate to interrupt. All right. So first, let's talk about a review of directed trust structures. And it sounds like California passed a new directed trust statute that was effective at the beginning of this year. And you had an informative session on this. I did review those materials. So as I said, I'm not planning to rehash that discussion, but I do want to build on it and go a little bit deeper about how these directed trust structures present themselves. And there are 47 states that have directed trust statutes. And even prior to the enactment of those types of statutes, many of us were drafting directed trust concepts into our trust, just as a matter of common law. It's not dependent on a statute to have a directed trust. But my experience is that most of the California irrevocable trusts tend to end up not as California trusts. At least maybe maybe my experience is limited, but I've spent a lot of time working in Nevada trusts and Delaware trusts and South Dakota trusts. Is that consistent? How many of you on a regular basis are interacting with California irrevocable trusts? Okay, so yeah, some of you are, so a handful of them. Of course, it depends who people want to name as trustee and whether they want to name an out-of-state trustee. But because of California income taxes, it seems people are in this state quite often trying to set up their trusts elsewhere. So I'm not going to focus specifically on the California statute. I'm just going to talk about directed trusts more generally. So this is a little bit small, and these particular slides were not in the outline because I was still tinkering with them pretty recently. I do adjust these slides quite a bit from time to time, constantly improving them, but I find them very, very helpful to really lay out the different roles in a directed trust. So this is just this week's version, but if anyone's interested in them, because I do know that it's a little bit blurry from the projector, I'm happy if you email me to send you copies of any of these slides. So what are the roles in the directed trust structure? So first we have our settlor. That's the person who has set up the trust, sometimes called the grantor when it's a grantor trust. But as I tell my students, I prefer us to focus on the word settlor when we're talking about the person who set up the trust, because that might not end up being the grantor. And my students get very confused between the income tax concept of having a grantor trust and the property reality of a settlor settling a trust. So I try to use the term settlor unless I'm actually talking about a grantor trust. So the settlor is the party who has set up the trust and set forth the terms of the trust. Pretty straightforward. Next, in many trusts, we have the role of a trust protector. And some of you might see trusts where at the outset, someone's setting up an irrevocable trust and they appoint someone to serve as trust protector who's going to be like a policeman, who's going to be supervising what's going on in the trust. But we have seen through litigation that that trust protector position is pretty nebulous. If you want somebody who's going to be involved in the trust and just standing around watching the trust, if you expect them to be doing something, oftentimes it's better to just name them a co-trustee, because then they will have standing legally. If there's a problem with the trust, they could, if they don't have any legal standing and they're just a trust protector, they can go to court and the court can tell them, sorry, you have no standing. So oftentimes the trust protector role, the way that I see it, out in practice across the country is it's just an empty role. The idea is not that the trust protector is a policeman who's named on day one, who somehow has responsibilities for, being a check and balance against the trustee or supervising what the trustee is doing. If that's what you want, name them as a co-trustee and then they have power. But instead, the trust protector is often a vacant role that can be appointed temporarily, not as a policeman, but as a surgeon, to be appointed to come in and fix a problem with the trust so that you don't have to go to court and fix the trust. And there again, I started practicing in 1997. We started routinely putting the ability to appoint a trust protector in our trust back in 1998. It was a concept from England. I saw it in one of our clients' trusts and said, why wouldn't we do this in every single trust? Every irrevocable trust either started as an irrevocable trust or started as a revocable trust, which then became irrevocable. So why not always build in that flexibility of having a trust protector who could step in and perform surgery on the trust, change the tax provisions to adjust to the new law, change the investment provisions. We see old trusts where LLCs didn't exist, or they can't invest in an option strategy, or all sorts of limitations in these trusts. But the idea of having a trust protector who can come in and perform surgery can be very helpful. The other benefit of naming a trust protector can be if the trust protector is a non-fiduciary, they can hold what's essentially a power of appointment and can actually add beneficiaries to the trust. It's not usually such a great idea to give them the power to remove beneficiaries, because the beneficiaries who get removed, and we've seen litigation about this, may argue that they were breaching some kind of a fiduciary duty. But being able to add beneficiaries to a trust is very powerful. That allows you to have trusts where there are springing beneficiaries. So people sometimes set up domestic asset protection trusts. Well, you don't have to set up a domestic asset protection trust on day one. If you have a trust protector who can add back the settlor as a permissible beneficiary, you can create what's called a springing domestic asset protection trust. Similarly, many of you are probably seeing clients set up these lifetime family trusts that we call SLATs, spousal lifetime access trusts, while they're trying to use their exemptions. Well, the beauty of a trust protector who could add a beneficiary is on day one, you don't need to name the spouse as a current beneficiary. You could have it be a springing SLAT where the trust protector has the power. An independent party who is a non-fiduciary has the ability to add in the spouse as a permissible beneficiary in the future. So these trust protector roles, if used well, can be very, very helpful. So then we get into the core of what people are talking about when they say a divided trusteeship. What they mean by that is that there is a trustee who can have varying powers, but often it's referred to, as you'll see in the middle here, as the administrative trustee. So a trustee who is purely an administrative trustee has very little power in the instrument. They can hold the assets as a custodian, they can file tax returns, they can file accountings and share that information with the beneficiaries. But if they're purely an administrative trustee, they need an investment director to tell them what to do on the investment side, and they need a distribution director to tell them what to do on the distribution side. Some of these names, and I liked looking at your presentation from May, where it looks like in California, you are in fact calling these roles trust investment director and trust distribution director. That is what I refer to them as, either an investment direction advisor or an investment director. But you will see a lot of documents out there and even statutes in some of the states like Delaware, which is one of the biggest directed trust statute states there is, where they call that role, instead of the investment director, they call them the investment advisor. Well, for those of us at RIAs who get hired by clients to be the investment advisor, when we are working in a document that tried to name that party as an investment advisor, it is very confusing, because what you do is you have the investment advisor, and by the way, the Delaware statute has it with an E, advisor with an E, but none of the documents will say advisor with an E. They'll always say advisor with an OR, with an OR as the OR. But so you then have the investment advisor sending a direction to the trustee saying to have the investment advisor, meaning the RIA or whoever it is who's actually helping with the investments, do something. So I commend California and encourage you all, to the extent that you do have influence over the way that clients are drafting documents, to continue to use that language. My old firm, as I said, we started doing divided trust structures back in the late 90s as well. But, before, actually, they might have been doing it even before that, before there were any directed statutes. There's no reason under common law that you can't divide up these roles. And they always called it the investment counselor, which is another term I like, but has not been showing up in statutes. So that's that role. The distribution director, as you would assume, is the party who then directs the administrative trustee regarding distributions. Now, that can be problematic if the distribution director is a related or subordinate party, is a beneficiary, or a related or subordinate party to the settlor or to a beneficiary, because we don't want those kinds of fiduciaries to be making decisions about distributions for anything that is not subject to an ascertainable standard. So I caution you, as you look at this, you want to make sure that if it's a purely administrative trustee, that distributions can be made or encouraged or directed to be made by a distribution director who is not a related or subordinate party. You want somebody who's an independent distribution director so that they can direct broad distributions. And I'm going to give an example in a minute of a compromise position. But for a purely administrative trustee who doesn't do anything or make decisions, the South Dakota Trust Company had that model where all they were willing to do was be an administrative trustee, and they had to be fully directed for investments and distributions. So the next box down there, the one that's in purple, is because that's kind of where we see my firm fitting in, and that's our firm color. That's the investment advisor, oftentimes an RIA, but it could be, could be anyone. It could be a broker dealer, it could be a bank or trust company who is actually managing the assets in a directed trust statute. And as I said, we're going to mostly sign a contract that's going to say that we're being hired as investment advisor, either on a discretionary basis or a non-discretionary basis. When it is on a discretionary basis, you don't need to get constant interaction with the investment direction advisor. But if you're being hired and it's non-discretionary, you do need somebody who has an official role at the trust to be weighing in on the investments. Because of the investment, the divided trust structure and the role of the investment director, oftentimes the only thing they're allowed to do under the statute is tell the administrative trustee what to do. So it ends up being a kind of inefficient approach, if you think about it, that the investment director tells the administrative trustee to hire the investment manager, and then tells as there are investments and other things happening, the investment director needs to tell the administrative trustee to sign this subscription agreement or invest in this way or do this thing. So it's just important to understand that where that investment director is not also a co-trustee who's empowered to act and sign things on behalf of the trust, you end up with this extra layer of communications and steps that need to be taken. Then we move down, we have our beneficiaries, of course. Every trust will have at least one beneficiary. And the beneficiaries are the ones, of course, for whom the property is being held, and that all of these fiduciaries, the administrative trustee, investment director, and distribution director, are communicating with the beneficiaries to figure out their needs and to make sure that there's sufficient cash flow for distributions, which can also be complicated if the distribution director is a different party than the investment director. The distribution director can get a request from a beneficiary, I need a distribution, but the investment director is the one who can control the purse strings as to whether or not there's going to be a sale or there's going to be something to create enough liquidity or doing the cash flow planning. So without good communication, these directed trust models out in practice can become very complicated and create a lot of conflict. So they have to be done very well. I also have designated rep on here. My memory from a trust I was working on is that California might not have a statute that allows for designated representatives. Am I misremembering? Do you have those now? Anyone? Do you have designated representatives? No. All right. So yeah, I remember that causing problems because I wrote a memo on behalf of my client to the lawyer for the client who had moved from another state and now was here and wanted to continue to have designated reps for minor children. And they said, oh, that's not really a thing here. So I guess that's still the case. But in most of the states where I operate, and even in Illinois, where it's subject to a particular age, oftentimes the settlor, when they're setting up this trust, can decide the trustee doesn't need to give accountings or crummy notices or other information to all the beneficiaries of the trust, because oftentimes there's all the different generations and all the different family members. They only need to give that information either to one beneficiary who is designated rep for the other beneficiaries, or to a third party if the beneficiaries are children or not of whatever age. And ordinarily you would need to give them information when they turn 18 or 21 or whatever the age of majority is. But with the designated rep, you can prolong that. So for example, in our state, you can give information to the designated rep until the beneficiary is 28 years old. And in states like Delaware, you could have a designated rep forever, regardless of the age of the beneficiaries. So that becomes a very critical piece to this picture, where you don't want, as a settlor, and for those of you who have influence over how your clients draft their documents, it's very nice to be able to say, my child is going to be the designated representative for all of their descendants for that child's entire life until that child becomes incapacitated. That gives you the flexibility to have more beneficiaries, but not requiring the trustee to give them all sorts of information. So maybe California will change their law at some point, or until then, I'm sure, as I saw from the hand raise, many of you are also working with clients who are setting up trusts in Nevada and Delaware and South Dakota and other states. All right, let's keep going. So as I said, let's keep going to So as I said, the key with these directed trust structures is, what is the communication going to be looking like? And so it is important, when you have influence over your clients, that the settlor gives sufficient guidance, both in the trust instrument and, even better, in a side letter of wishes, telling the trustees what it is that the settlor is hoping to accomplish. We prefer not to see trusts that go into too much detail, that what the definitions of best interests mean, what the definitions of health support and education. Typically, you want the document to be as broad as possible and as flexible as possible. But then you would want to make sure that there's some kind of a side letter or some kind of guidance that the settlor who set up the trust is leaving for all of these other parties, so that through the generations, as they're administering the trust, they have some guidance for what did the settlor mean. And the beauty about these letters of wishes is that while everything in the trust is mandated and can cause you to go to court and have litigation, these side letters, if it doesn't fit the circumstances, the trustee has their fiduciary discretion to deviate from that. Well, yes, they said that, back in 1995 when they signed the trust, or in 2012 when they scrambled and signed the trust, but now it's 2024, it's 2020, 2050. And, as Bill said, I do this estate planning for modern families treatise with Wendy Goff. Things change all the time, right? The definition of descendant changes, and the definition of spouse or life partner changes. And a lot of times these letters of wishes do become, outdated as times change. And if the settlor is deceased and can't have a conversation with the trustees and fiduciaries to better explain what they meant with settlor intent, that can be, that kind of flexibility is really useful. Yeah. So the idea of the letter of wishes is it's supposed to be a side document that in most cases is hopefully not discoverable, even because it's not within the four corners of the document. Sometimes the letters of wishes, they encourage to be shared with the beneficiaries. We have some, different templates and questionnaires. Letters of wishes can be all kinds of things. Like, when I die, these are my arrangements at death. These are how I want to divide my tangible property. If I'm incapacitated or I have some type of traumatic brain injury and I can't speak for myself, this is the type of care that I want. I mean, what's nice about letters of wishes is you can put all kinds of things in there. You can have a section about, while my surviving spouse is alive, these are what I have in mind. After my surviving spouse is deceased, this is what I want for my children and grandchildren. But the idea is, if they're done well, that they are not they're part of the official trust file, and whoever the administrative trustee is would be the party who's responsible for keeping those things. Thank you. No, please, as I said, interrupt. I love it when it's dynamic, although I know we're going to run out of time, even if you gave me till 9:15. All right. So the administrative trustee, if they're only the trustee, and I alluded to this earlier, the key is going to be figuring out the communication between the administrative trustee, any distribution directors, and any investment directors, because unless those three parties are having regular meetings and having transparency and sharing information, things are not going to go smoothly, and everyone is going to be unhappy if the beneficiaries are not getting the distributions that they need because everything's tied up in illiquid investments and there's no cash flow, or if it's not a grantor trust and there's taxes that need to be paid. Like, these parties have to actually get together, coordinate, and then then all three of those parties really also should be communicating with the beneficiaries, even though the trust investment director and distribution director are not officially co-trustees in this type of a model. They do have fiduciary duties, and in California, they have fiduciary duties. In some states, you're allowed to say that they don't, but that is more rare. Typically, if the administrative trustee really is not required to supervise them, and that's what they're used to in the early days of these directed trust statutes. There were a lot of cases, especially in Delaware, where the administrative trustee was getting sued for letting the investment director give bad advice. And I did work on this back then about fiduciary duties and the ethical responsibilities of a trustee. My own view is that if you're the trustee and you're being directed to do something that is not in the best interests of your beneficiaries, I think that you do have a fiduciary duty to do something, even when the statutes now will relieve you of that obligation. As we encourage our clients, you want to do not just the bare minimum of what the law requires. You want to actually help your beneficiaries, and you want to be ethical, and you want to do the right thing. And if you see a problem, you should at least point it out to the parties that could have standing to object to these directions. And perhaps you could even refuse entirely if you're being asked to do something that's fraudulent, or that is going to be a problem in the cash flow. You know, if having a conversation doesn't help, there could be a need to take some legal action. Even though the statute will say you're not obligated to, that doesn't mean that you cannot insert yourself and try to make sure that the beneficiaries are not going to have significant problems because you've got a rogue investment director who is investing in their own bad deals and using the trust as their own piggy bank rather than caring about the beneficiaries. So all of these structures, however, are not going to be cookie cutter. You know, all of these parties need to communicate with each other, but there will be variations. So on the next slide, I'm going to show one of my favorite variations. And this is what I actually most often see in states like Delaware and Nevada and South Dakota when we're using a directed trust statute. So what happens typically if you see this family co-investment LLC, for a directed trust, in order to keep the fees down and keep what the administrative or sole or co-trustee is doing to, you know, keep it, you know, to a minimum so that they're not involved in the investment decisions. The simplest thing to do is really wrap the investments in closely held entities. And oftentimes there's one big investment LLC. Sometimes there's you know, that might then have sub investment LLCs. People used to call these family limited partnerships for investing. We don't call them that anymore. That raises too many red flags because family limited partnerships have been attacked and sound like you're doing something that you're not supposed to be doing just to get discounts. So we say family co-investment entities or closely held businesses with an investment focus. And just a side note, our families who are setting up these co-investment LLCs are not engaged in commerce. So I know we all are aware, most of you are probably aware, some of you who are real estate professionals might not be aware of this, but you probably should be for your clients who own their, have you ever had a program on the Corporate Transparency Act yet? That's where I'm going with this. So there's now a federal requirement with FinCEN that all of our clients who have an LLC or one of these closely held entities, is if they don't have 20 employees, they're supposed to be filing with FinCEN all of this personal information. There have been some lawsuits in Alabama. They found that unconstitutional. There's 3 others, but it only applied to their members. I was speaking to a family office group just a couple of weeks ago. And I said, I don't know why the family office groups haven't filed any lawsuits on behalf of their members. So I've been told as of last week that they are trying to do something. But in the meantime, our clients do have to file for FinCEN for these co-investment entities by the end of this year, which is a looming deadline and something very unpleasant. But the unconstitutional aspect of it, I think, especially for our high net worth families, is pretty compelling. This is a family entity to facilitate the investments by the trusts. But so these co-investment entities are then owned by one or more trusts. They will have an independent trustee, which is typically a corporate trustee, but it doesn't have to be. It could be a professional, an attorney or an accountant or a family friend or business partner could be the independent trustee. But we'd like to have independent trustees or independent co-trustees who then can make distributions for those non-ascertainable standards I was talking about, who can make a best interest distribution for a child to start a business or to buy a house, which doesn't technically fall under support, or to engage in other things that you need an independent trustee for. And so it's very helpful. It's very helpful to have an independent trustee. They can do things like make decisions to reimburse the grantor for taxes. They can make loans to the grantor. And I'm saying grantor because these are grantor trusts. If you're making loans to your settlor, and they can also verify the value if your grantor is trying to do a swap into the trust. So having an independent trustee is in fact a good idea. So we see them hiring usually an independent trust company who is not interested in investing and just wants to be helpful. But my preference are not the independent trust companies that will only be administrative trustees, because then they're not going to do some of those things I was just talking about, especially the best interest distributions. They're not going to want to go anywhere near that. And what that allows, if you have an independent trustee who's willing to make distributions, is you can have a family member who can then be co-trustee. So if this is one of those slats I was talking about earlier, you can have the spouse be the co-trustee with the independent trustee. And they can even have, as it says here, all the powers of a trust investment director, and they can have the powers of trust distribution director or advisor, but only up to the HEMS standard, only up to the ascertainable standard. You do not want your spouse, or if it's one of the children as primary beneficiary, being a co-trustee with any powers to make distributions beyond the health support and education. But that ends up being a really nice compromise, and clients really enjoy it. And then you just build into the trust language that says that any individual co-trustee has all the powers of an investment direction advisor, and if the co-trustee is a related or subordinate party, then they're limited to advising on a HEMS standard. So then again, we do typically see the investments through the LLC being managed by the investment manager, investment advisor. And then we see the beneficiaries. Again, in an ideal world, these trusts are going to have a broad definition of beneficiaries, so that while the surviving spouse is still alive, the surviving spouse and all their descendants can be beneficiaries. And then at each generation, because David Handler, who is a pretty well-known estate planning professional, also, speaks at Heckerling and is pretty well known for some of his strategies. But he always said children should share toys when they are young, but never money when they get old. I don't know if I'm alone, but I have definitely seen when children are stuck together in a trust as adults that it can be very problematic sometimes. So better to divide the trust at each generation, so each family line has their own assets. They're not fighting with their siblings and their cousins, but the parent, if you've got a client, they have 3 children, each of their 3 children can be the primary beneficiary. They can be the co-trustee. They can have the ability to appoint and remove trustees. And that can just work really well. And then, as I said earlier, they can be the they can be the designated representative to receive notices and accountings for their children. Oftentimes, even in states like Delaware, if they are acting as co-trustee, you might want to have their spouse or some person who isn't a trustee, because technically the designated representative is the one who is approving the trustee's account. So especially if there's a sole trustee, you never want them to be designated representative, because they would be approving their own accounts on behalf of the children or grandchildren. All right. And then, of course, all of these parties are going to have their legal and tax advisors. Next slide. All right. So here again, this is one of those communication slides. And once again, having the individual co-trustee who also has the powers of a director simplifies things, because there's just one person instead of 3 different people. But and I'm sorry, now I'm going to go back to that original slide. Don't change the slide. I had said person or persons. All of these roles can be committees too. You can have an investment direction committee that's comprised of multiple people, and you can have a distribution committee. This ties in later when we talk about private trust companies as well. But so these directors do not need to be individuals. They could also be a committee of individuals. But guess what that does to communication? It makes it even more confusing. You've got more people involved. And so you really need clients if you're going to set up the more complicated versions of these structures, or let alone the private trust companies we'll talk about. You really need clients who can handle that kind of complexity, whose estates are large enough that it really warrants that type of expense. And you need lawyers who really know what they're doing when they're drafting these structures in order for things to work. And then you need to have good, aside from the structures themselves, you need to have good consultants and others who are involved, consigliaries who are helping families figure out like what are the informal structures for this? What are the processes for the communication? Because the communication is not going to be built into the trust document. That all is going to be family governance stuff that somebody needs to organize when you have these more complex structures. All right, let's move on now. Well, actually, maybe I should pause before I move on. Any specific questions about directed trust before I move on? All right, great. Hopefully that was oh, yes, one in the back. Well, I just showed you my favorite version. With my favorite version, everything gets easier. Everything is simple. When it's being implemented the way that I just showed you as my example, I find it is easy because you're dealing with just the one person who is the stakeholder. They're the primary beneficiary. These assets are mostly for them, and they are empowered by the settlor, whoever that was. I mean, it could be their spouse, or it could be a parent or grandparent. They really are given stewardship responsibility because they're figuring out the investments. And guess what? The investments are for them and their clients. They might not be doing the investments themselves. Very few of our clients out in the world, although 25% of my clients are professional investors themselves and feel comfortable with investing. But most of our clients don't want to handle all the investment themselves. They want to be able to hire someone and delegate and have them do the investments. So I find that structure simplifies things. Some of these other structures, and I should say one more thing, which is what I was just describing was an irrevocable trust. I saw someone the other day set up this structure for a revocable trust, and it's making me bonkers because it's like they've got a trust protector who's acting immediately. They've got the settlor. They have a corporate trustee who's a directed trustee. They have one or two people who are the investment directors. They have one or two people, and the assets. I think maybe it's like $500 million that's in this revocable trust. So they can afford that kind of complexity. But even when clients can afford that kind of complexity, it's still really unpleasant and they don't always like it. And you've got to find people. They have a hard enough time just finding who's the trustee going to be, let alone now I need a trust protector and I need a direction advisor. So I do think that example I gave you where it's simplified. It's this, you try to have the family member fill as many roles as you can, and then you get an independent trustee who can partner with them to do the things that they can't do themselves and to provide some objectivity and professionalism. I find that system actually simplifies things. Okay. So now let's talk about family offices. And I would be remiss if I didn't give a shout out to some people that you probably have never heard of, but who have done family office presentations with me before. So these slides do reflect input from Anita Sarafa, who also I have to give credit to. She's a dear colleague of mine at JP Morgan, who had done the very first draft of the outline that you see before you. I ran a red line. It's not really recognizable, but I still give her a lot of credit for getting me set up for that. And then Bobby Beerhalls from McDermott, she and I presented a similar presentation to the UCLA, I guess it's their tax institute, or it was some kind of something. We did it virtually, sadly, because it was during the pandemic, because I had so wanted any excuse, as I said, to come to California. But a lot of these slides are from Bobby and from McDermott, and I'm very grateful to McDermott for their fine work. In my career, most of the family office structuring that we did was with McDermott, and so they have a really good handle on how to do this. So, all right, and also Family Office Exchange. Some of their slides are in there as well, my dear friends over there. And they're a tremendous resource for clients who are trying to decide whether to set up a family office and figure out what that should look like to get involved with the Family Office Exchange, which is a national group as well. It's been around for a long time. I cite Sarah Hamilton, who's the founder. I think she founded the Family Office Exchange in 1998. And she really is a pioneer, both in coining the term family office or promoting the term family office and really, building this industry. So now let's start to think about what is a family office. Well, that's okay. I hadn't quite gotten there yet, but many of you have probably heard the adage, and I'm going to do a hand raise. How many of you heard the adage? You've seen one family office, you've seen one family office. Yeah, that's pretty much what people say about family offices. But it is still important to understand what we mean. And the reason people say that is because all families are different. And so all family offices are different, and, all companies are different, right? There's always going to be subtle differences. But these days, the term family office has become very pervasive. Back in the late 90s and early 2000s, most people had no idea what a family office was. When my firm was founded in 1997, even though we were founded to be a multifamily office, people had this idea, well, family offices just have bad investments, so we don't want to call ourselves a multifamily office, or people will think that we're not good at investing. So it wasn't a very popular thing to say that you were a family office back then. But now family office is everywhere. Everybody wants to, your clients all want to have a family office, even if it's not a real family office. They just want to, it's a status symbol that they have a family office. All of the different financial institutions want to have a family, family office services to serve family offices. So what do we mean? The idea of family offices is that they're designed to serve ultra high net worth clients. And while the definition of ultra high net worth client used to be 25 million, it is now $30 million. So you're not really even talking about the family office world until you're talking to clients who have at least $30 million and then exploring their options with them. And from what I have observed in this part of the country, you probably all have lots of clients who fit into that category. So there were some Schwab materials from 2022 that I saw that said there were over 100,000 family offices in the U.S. Or I'm sorry, no, over 100,000 families who have over $30 million in the U.S. That's a big difference. There's about 30,000 centimillionaires in the entire world, which is, not that many if you look at the US perspective. And there's about 2,600 billionaires in the world. In my view, if someone wants to have a fully functioning single family office and they want to try to hire talent to actually run this office, and they want to put in place the structures that they need and join the organizations that they need, really, when we're talking about single family offices, we usually are talking about clients who are in the billionaire group, not just the 30 million or centimillionaires. There's an estimate that there's about 6,000 to 8,000 single family offices for those billionaires and centimillionaires out there. So while there's no typical family office, the common functions do include that there's going to be some administration provided, centralizing administration and record keeping and tax compliance for family members and for all their trusts and entities. We work with 120 families, but I think we work with over 400 entities because they all have lots of trusts and LLCs and other entities and households within the family. They help with investments or wealth management, which is pretty self-explanatory. The family office helps figure out solutions to invest the assets and manage the wealth. They can serve fiduciary functions, providing fiduciary services, sometimes trustee services as well, to act as trustee for the various family trusts or manager for the family entities. That could also be a private trust company as well that is acting in this capacity. But I will also note that historically, some of those self-report, we have a family office, are really families that just have somebody who helps them with bill pay or helps them with concierge services like coordinating house management, helping just with the trust services. But ultimately, there are two different types of family offices that are providing these services. Slide. So the first are the single family offices I was talking about. These are offices that are created and managed and owned just by one family. They can be investment only or concierge only. They could have a minimal staff. I have some clients who have a family office with just one employee. I have seen other family offices where there could be, for a large enough family that can afford it, there could be, 100 employees. So it really can vary significantly depending on what the size of the family is, what the needs are of the family, and whether it's an offshoot of their family business or whether they're starting something from scratch. But the key about the single family office is that it qualifies for the SEC family office exemption. And so the company does not need to register as a registered investment advisor with the SEC. So that is a big deal for families, this exception that they don't need to register because they're not offering services to the public. They're only helping the family. Then the next type of family office is the multifamily office. And that, as you would suspect, is a firm that serves the needs of more than one family. And what it's doing is for their clients, they're combining all of their resources. As I said, it's really expensive for a single family office to hire and maintain talent and train them and get all the insurance they need and all the risk management and do the training, and people are constantly leaving. So the multifamily office consolidates all of those services for a number of families. And those are families, as I say, who are not related to each other by blood or by law. So when Bill says that we work with 120 families, those are 120 separate families who are not related by blood or law. So there's different models of multifamily offices and where they came from or how they started. So a lot of multifamily offices started out as single family offices, but the family realized, hey, it's really expensive to run this family office. And now we have hired some people and developed some things. Let's make this into a business. Let's bring in other families and we can charge them more than, we're paying, and we can benefit from them coming in and infusing capital, and we can charge them to manage their assets. And we can leverage this infrastructure that we've built to serve other families. So that's one model where they bring in outside families to offset the costs of operation and turn this into a revenue generating business. Other multifamily offices have multiple founders. So you could have clients who there's 3 folks who are not related by blood or law who are running a business together, and they're getting ready to have a liquidity event and cash out, and they enjoy working together and say, okay, we've been so successful all these years working together, let's set up a multifamily office rather than each of us setting up our own single family office. Or maybe they can't afford to do a single family office because as I said, it's expensive. And then the final model is an independent multifamily office. These are wealth management firms that were formed by professionals to serve the needs of families. They're not in their ideal form. They're not favoring the founding family over other families. They, love all their families equally and give them all the same services because it's an independently owned company. The family does not own and control it, which can also be beneficial to clients in how the firms are run and how they're managed, with the client focus first. and sometimes not having those family dynamics of family members who want to be involved in running the business. So one Fox survey indicates that the average multifamily office has about 131 client relationships, and an average of about 5.1 billion, so about $40 million per client. So that's the average MFO. That to me sounds like a little bit small in terms of the size per client, but it is 40 million per client is over that $30 million ultra high net worth threshold. Now, the services are going to vary significantly across family offices, and I'll speed up a little bit. Slide. Yeah. This is a part of a pro con that I had put together for, the example was in fact 3 business owners who were trying to decide, should we set up our own single family offices? Should we together set up a multifamily office? Should we do a turnkey and join an existing multifamily office? Or should we, just do traditional private wealth management, like at a broker dealer or a bank? But the 2 columns that are relevant here are looking at the pros and cons of, should you set up a single family office? Should you build it, or should you buy it? As you can imagine, the pros and cons are what you would expect when you're setting it up yourself. You have more control, less professionalism, perhaps. If you're setting up a single family office, you need to make sure that it fits within the family office exception. So you can't let in other people who aren't related by blood or law. Other than a few exceptions for the executives that you hire, they can have some benefits. All right, let's go to the next slide. So this is on page 46 of your materials, because I do recognize it's small and a little bit blurry. This is Exhibit C, but this is the menu of the different services that a family office can offer, or one version of it. But typically they're going to be helping with investments, setting up the IPS, portfolio construction, manager selection. They're going to help with wealth transfer planning, helping the families design their trusts, implement their estate plans. A lot of multifamily offices, they're not going to draft it themselves. Like even in single family offices, if they have a general counsel, that person isn't typically going to draft the documents. They're going to all use outside counsel, independent counsel, but it's about coordinating with those lawyers. So, I practiced law for 17 years. I don't practice law anymore. I can do a few things like draft a promissory note and then run it by counsel, or, a crummy notice form, but I can't sit down and draft a trust for my client, and people who work at MFOs and at SFOs should not typically be doing the actual drafting. The family offices also help with philanthropy, with private foundations, donor advised funds, working on the objectives, the mission statement, tracking grants, all of that, finding philanthropic consultants when needed. Help with financial planning. Cash flow is really critical for all of our clients, making sure there's enough money where it needs to be to make the capital calls and pay taxes and support their lifestyles. Information management, having a secure portal. Where are your clients' marriage certificates, divorce decrees, deeds for all of their real estate, all of the estate planning documents? Do your clients have them sitting in a vault somewhere? Or a safe somewhere? Do you have them in your vaults if you're a law firm that is providing full services? Where is everybody keeping things? The family office will make sure that there is a virtual portal where all of the important documents are being kept. And again, not always, not all family offices are going to do all of these things, but in an ideal world, this is the menu that clients are choosing from as to what services they're looking for in a family office. They help with family continuity and education. That's very common. You can get that elsewhere now, right? There's a lot of folks who are offering family education, financial literacy, cohort training. But typically it's the family office's responsibility to help put that in place. I've spent a lot of time talking to executives at single family offices because that's my job. My job is to help resource find, as Bill had said, I'm responsible for estate planning and estate and trust administration and philanthropy and rising gen engagement and education. Well, that means finding the right programs, even if you're not doing everything in-house. Tax coordination, some single-family offices do tax prep. Most multifamily offices don't, but at least coordinating that. Risk management, property and casualty insurance, security, cyber and personal lifestyle stuff like domestic employee management or private aviation, healthcare services. These are the idea with a family office is it's supposed to be providing integrated, comprehensive services, one-stop shopping, not necessarily because the family office is going to do everything itself for the family, but it will coordinate all these things to help the family live its life. And Fox has done some analysis on this. If you, the next two slides, I'm not going to spend a lot of time on these because these are in your materials as well as exhibits. But it just shows some of the research that, the average single family office employs about 8 to 9 full-time employees and engages 23 external service providers to help with all this kind of stuff. Like the lifestyle and concierge services, family engagement and education, philanthropic planning. And it's not on this slide, but the technology and cybersecurity is going to be outsourced in most cases by a family office or MFO to help their clients as well. All right, let's go on to family office structures. So when a client is setting up their own single family office, there's a lot of decisions that you need to help them think through. So how many of you have clients where you have been involved in helping them think through setting up a single family office? Okay, so yeah, just, 4 or 5 of you. So, not so many, but for those of you, this will be very familiar. So the next slide are the choices. So I talked already about the multifamily office. There's also something that gets promoted as a virtual family office where you don't actually hire an MFO. Tom Handler, who's based in Chicago, was sort of one of the architects of at least spreading the word about this concept of a virtual family office. But this is what you'll find also at a lot of broker dealers, sometimes law firms, where they'll say, we're not going to bother setting up a single family office and you're not going to hire a multifamily office, but we're going to just piecemeal it. We're going to figure out which of those services you need. And you're just going to, find all those services and kind of put it together. The key there, though, is accountability. Who is actually running all of these things? What's the succession plan if you're not hiring a company to manage the virtual family office? If you're hiring a sole practitioner who's going to be your guy, what happens if that person gets hit by a bus? So, these virtual family offices, the key there is to just figure out and to also do the cost comparison, because the idea with the virtual family office is it's supposed to save costs. And that might be the correct solution for a family that really doesn't have that much money or that still has an operating business and doesn't need to hire people in-house. But it's on the list and something to be explored. The next is the embedded family office. This is many of you will see this. This is just the classic family has an operating business and has an employee or two within the operating business. They call it the corner family office. The person who sits in that corner helps run our family office. And in those circumstances, the business is usually paying for this person to be providing these services to typically only to the founder or founders. But as you get into multi-gen families, it can get more complicated as children who are not involved in the business need an executive assistant to be doing everything for them, or concierge travel for people who are owners but don't actually run the business. So the corner office model works quite well for the family members who are involved in the business, because it's not that different than just having a bookkeeper, an executive assistant, someone in the company who's also helping with some of the personal side. Then we have the classic SFO structure. This is when the client has a liquidity event or realizes, I don't want people in my company all mixed up in my business, or I have children, adult children now who are not in the business who also need some resources and services. So then the family will set up a separate business to be its family office. And we're going to look at a slide that shows an example of that in a little bit. And then the profits interest model was designed by brilliant accountants and such to try to figure out, when a family is running a family office for itself, it's not with the operating business, when it's a corner office model, can deduct the expenses of these people that they've hired to do things for the family. But when the family sets up its own LLC or its own company for the sole purpose of taking care of the family, that is not deductible. And so the profits interest structure was like, well, what if we set up this family office business so that it's a real business, so that there's a management company and the people who are benefiting from it have to pay fees, and then there's actual, there's actual profits that are distributed. Now we've got a real business and we have something to offset those expenses. So that's really the idea behind the profits. And I'm simplifying, of course, significantly, but that's the evolution there. And then finally, some families will set up a private trust company, not as adjacent to their family office, but to actually be their family office. So instead of just setting up an LLC in a state, they'll set up a private trust company in that state that can help them with all of the various things that they need help with. So let's keep going. So who should own the family office? It could be owned outright by the founders in their revocable living trusts, but more often we will see that the irrevocable trusts that are benefiting the younger generations will be the owners. And the benefits of owning it in trust, of course, will be perpetual ownership. It can be structured to avoid future transfer taxes. It can be beneficially owned by the whole family and not just by the founders. Some of the downsides of that are it can be difficult to get cash from the trust into the business to operate it. But how do you get new cash into that trust? So you've got to make sure that that trust owns enough other assets that are generating income, or that there's loans that are being made from another family entity that holds cash. So the cash management aspect of having it in trust can be a little complicated. So there's not going to be a single right answer for who should own it. But then you look at who should, for who should own it, it's usually going to be a trust. But who should control the family office is not as clear cut. Should it be that the senior generation only controls it, which is typically what the founders will want? Should all of the family lines be represented in running it? So adult children, or each family line gets to elect somebody to be involved in the management. Now we get into all of the complicated family governance and family dynamics issues that you're dealing with a regular operating business. It's just now a family office that is not actually producing widgets or investing necessarily in real estate, although it could. I mean, if the family's business is investing, the business could be investing in real estate or doing private equity. So it really is a function of what the family is doing with its family office. All right. So I mentioned earlier the family office exemption. You can read about this in the outline for those of you who are helping people to set up family offices and need to understand the family office exemption. But it does have, as I said, a number of limitations as far as who can benefit from this family office. Next slide. Staffing the family office. Talent is a problem. Who is going to actually run this family office day to day? Are you hiring family members to do so, or outside professionals? And then how are you going to retain and train them and promote them? Next slide. I can see people starting to need to leave because he gave me till 9:15, but I know some of you were planning to leave at 9. Thank you for joining. Fee structures, how do you charge for the family office? Fixed fees, hourly fees, a percentage of resources used. You can have a lot of family conflict based on how the family structures paying for the family office. This is on pages 27 and 28 in the outline. Let's keep going. This is the profits interest fee structure that I was talking about. when the single family office is actually conducting a trade or business, it in most cases will be able to deduct the ordinary and necessary expenses of running that business, but there has to be significant entrepreneurial risk. So what if there are no profits? Someone needs to cough up funds or make a new capital investment in order to get the expenses of the family office paid, because you have employees now who expect to get paid, who are running the family office for you. The other key with the profits interest structure, next slide, is you've got to be attuned to the relevant cases. There was a Higgins case in 1941, which is in the footnote on footnote 18 on page 12 of your materials. This is what set the rule that you can't deduct the expenses unless you have an active trade or business. And so the lender case in 2017 was an example of a family office that was designed to be an active trade or business. But the key there is it can't just be family members. You have to, get like a random cousin involved in investing, and you need to have outside parties who are involved, because if the business is just by the family for the family, it's not going to be considered an active trade or business. Yes. Yeah, so you're usually looking up, so it's ancestors, you're looking down to descendants, and you're looking side to siblings. Yeah, so we had one, we don't have a lot of clients who end up, when we go through this analysis, we don't have a lot of clients who end up going with the lender structure, because it's like dad, mom, 2 daughters, 2 grandchildren, and that's who's going to be in charge of the control of things. But yeah, if you bring in like a first or second cousin, somebody who's not on, we look up, we look down, we look side. Yeah, the Hellman case was a problem, because the people who were actually managing the investments and the assets, and who owned the assets, were the same people. There was just too much overlap. So that case settled. That's on page 16. So let's keep going. I had promised, these are the actual illustrations. This is Exhibit A, and then the next one is Exhibit B. So I do encourage you to study those a little bit more closely on your own time, and, feel free to reach out with any questions. And now let's go to the last section. A few words on private trust companies. These are on pages 18 to 22 in the materials. So, what is a private trust company? This is a trust company that is owned entirely by the family, and it can serve as trustee for the benefit of those families' trusts. So it's not necessarily a family office, because the family might have a family office that's interacting with the private trust company, or the private trust company itself can be the family office. And the family members typically are going to be participating in governance. You do need independent parties who are on the board and who are involved in making distribution decisions. Again, there can't be too much overlap. So they are going to need to hire some folks to help them run their private trust company. And as I had referenced earlier with the directed trust statute, it's often going to be by committees. So you could have a committee. We have one family that does have a private trust company. We don't work with the entire family, but just some of the family members, and they have each trust has a different distribution committee, so that the beneficiary and their immediate family members can be on that distribution committee, along with some independent parties. And since there are so many different family lines, every trust will have almost every trust, your trust within the family line will have the same distribution committee, but cousins and more distant family members don't need to have the same distribution committee, but then they all have the same investment committee. And that is a structure that's within the private trust company. It doesn't need to be in the trust document itself, because it's at the divided trust structure is at the trust company level rather than being in the instrument. But as I said, it could be in combination. It could be both. You could have the family's private trust company serving as trustee, and it has its own committees, but then you have a trust that they're trustee of that has different distribution advisors and investment advisors, which means that they are directing the private trust company as essentially the administrative trustee. So again, you can see these things can get very complicated depending on the layers upon layers. If the trust is designed very simply, so it's just one trustee in charge of everything, and it's the private trust company in charge of everything, then all of those committees and the investment decisions and distribution decisions are all made at the trust company level. All right, let's flip to the next. Oh, this is what I was just talking about. Let's go to the next slide. And then let's just go here to the next slide after that. So what are the primary motivations for why clients want these private trust companies? They want to avoid the investment advisor registration. There could be some liability protection, or at least they think there might be. And I would say there's liability protection. If you're naming individual family members to act themselves as trustee, or individual friends or family office executives to act as trustee, I have advised family offices where they're doing that and naming an individual that they should set up a private trust company and name the private trust company if it's a large enough family that it warrants all the expenses. And that because of where you put your private trust company, often in Wyoming, South Dakota, Nevada, Tennessee for a while was trying to attract a lot of private trust company business, New Hampshire, where you put it, you're trying to get benefits, tax benefits. Like I said, a lot of my California clients are working with trustees out of state for the same reason. Next slide. Additional reasons for forming the private trust companies, long-term succession planning. Now you can name a trust company rather than naming individuals. And that means if the individual gets hit by a bus, there's going to be a successor. It does permit the family themselves to, in some capacity, not every single family member is going to get a vote, but it allows the family members who are running the trust company to select the outside advisors who are going to be involved in their trust company. And it does give them more control. It's a lot better for the family than having to work with a professional trustee who may not be aligned with the family's desires. They also point to increased family privacy. They're not interacting with a bunch of strangers at a public trust company that they hired. It's people that they've hired and trained, and can keep things quiet for what's going on with the family. They're also a lot less likely to seek court instructions. If you hire a well-known public trust company and you ask them to do something or be involved in something, they might want to rush to court and get court blessing and get court instructions or approval. So there can be some benefits. Next slide. Choice of jurisdiction. They're going to be set up in a state that does have a statute that sets forth what happens with a private trust company. Some of the states have regulated private trust companies and some have unregulated. I would say Nevada, Wyoming, South Dakota, Tennessee, and New Hampshire are where we see these the most. Next slide. This is a sample organizational structure for what a private trust company might look like. And you can see there's the private trust company in the middle. It's going to be owned by a family trust so that the family members are the beneficiaries. The private trust companies aren't typically run at a profit or at a large profit, but if they were growing in value, the trust would benefit from that, and therefore the family members who are the beneficiaries of that trust. You are going to want to have a board of directors. That board of directors is going to have to meet in the state where you've set it up. You're going to need to have independent directors in addition to family members, so it's not going to be entirely family run. And then you see it, the decision makers at the bottom, there's going to be different committees, as I mentioned. Next slide, and I'm almost at the end here at 9:13. What are the disadvantages of the private trust companies? The initial setup costs can be quite expensive. One of my first projects ever in 1998, before there was any private trust companies in any part of the country, I had to do a 50-state survey for one of the largest families in the country to help them figure out where they should set up their public trust company that could operate as a family trust company. And it's been, gratifying that now a lot lot of states have been enacting these private trust company statutes that make it a lot easier for families like that who it makes sense for them. But I have a blog that I did many years ago called like Private Trust Companies Don't Believe the Hype. And this was in response to a newspaper article being like, do you have $100 million? You should consider a private trust company. Again, for single family offices and private trust companies, I would argue that it makes sense only for clients who at least are billionaires or who, because of their complex operating business structure and number of trusts, that it really makes sense for them to invest in the overhead of setting these up. And there are a lot of other trust companies in these states like Wyoming and Nevada and South Dakota that will help make it turnkey so they can keep the cost down a little bit, but there still is a lot that's involved in setting up these private trust companies. And as I argued at the very beginning, if you have one of those well-drafted, directed trusts that is structured to allow the parties that you want to have control of things and keep family members involved and give each generation the autonomy to steward the funds themselves, I would argue that most families, between the combination of hiring a multifamily office and working with an independent trust company and having a good directed trust structure, can keep their costs down and function with simplicity. So I thank you so much for your attention. The next slide is Q&A. I'll stick around for Q&A and please reach out to me anytime. And then the final slide is just my thank you to all of you for your attention.
Kim, thank you so very much. And a whirlwind tour in a short time frame of the family office and beyond. Really appreciate it. Thank you all for staying and your attention. Our September 3rd meeting is with Lisa Rayberg and John Kramer talking about the life settlement world. Certainly want to thank our nonprofit spotlight, Executive Director Rosalind Knox and Angela Panella of the San Diego Brain Injury Foundation. Thanks so much for your support.